Okay. Oh, I'm so happy. Okay. Hello, everybody. It is great to see you all. I want to start by just giving a great note of praise, all the work that's happening outside of class, all the online work has just been incredible. And I hope that I'm being very rigorous in grading it. If you're getting high scores, it's because you're doing stupendous work. If you're losing a point here or there, it is so much better to lose a point here or there and get it finalized for your exam. So I really hope you'll follow up, make sure you're looking at the feedback that I'm giving, and follow up if there's any questions you have whatsoever about the material. We're alarmingly close to the exam, and I hate to be the one to emphasize that. I realize everybody already knows that, but I just really want to push everyone to start pulling together these materials, these charts that you're making. Open book exam, I think you should be moving toward having a topic organized set of materials that are ready to go with your statutes handy, your charts handy, and client counseling tips. And so today's lawyering lab is unequivocally the calmest and least jam-packed lawyering lab we have. So I really want to make sure today, especially, that if you have any questions about equitable distribution, spousal support, or prenups, that we address them tonight. Those are three topics. The prenups is one of the, sometimes it's tested, sometimes it's not, but spousal support and equitable distribution are almost always tested. So I really want to make sure we take our sweet time tonight and get those materials, start to move them toward exam readiness. As you're doing so in these lawyering labs, we are especially focused on the client counseling pieces of it. What are the things that go into your exam that don't jump off the page from the statute? And so that's really what we're going to try to focus on tonight. I don't have anyone prepared to be on call for any one thing. I just have a list of everyone in the class, and lawyering labs count for 10 points each week. So I'm just going to leave you guys to jump in and participate when you feel comfortable on material you feel comfortable, but make sure you find a way to participate tonight. But I think that's better for everyone given where we are. In contrast, next week is a very busy lawyering lab. We're going to practice child support calculations, which usually require a little bit of repetition. So we want to make sure we don't short shrift that. And we're also studying parentage. So next week's busy. So enjoy the peace and calm tonight. And let's make sure we finalize equitable distribution, spousal support, and prenups. So I'm actually going to start us off with equitable distribution. That's where we ended up. And so I think it just makes sense to begin right back here. And so I assigned everyone to prepare a practice and one more practice problem on equitable distribution. And I thought I had it ready to pop up here. Let's see if I do. Anyway, so I assigned us. Does everybody have their fact pattern handy? It's the one with Bill and Brenda. Does everybody have it handy? If anyone needs it, I can find a way to get it up on the screen. But
I have it handy.
You do or don't?
I do.
Okay, good. Well, once we get going, I'll get it up on the screen either way. Let's see if I'm trying to find it. But anyway, let's go ahead and get started. It's a short fact pattern, but it's a perfect chance for us to practice applying our equitable distribution models. Actually, let me just pause for a second. I think I'll feel better if I have it up on the screen, just in case there's anyone who does that. Just give me 1 second. I apologize. I thought I had this queued up. Oh, no, I just can't find it anywhere. Oh, I'm so sorry. This is my worst online nightmare.
Professor, somebody put it in the chat.
Oh, you're my hero. Thank you. Okay, beautiful. Thank you, Olivia. All right, perfect. So let me pop this up, and we're going to use this. This might be this is the second to last time that we will work through a equitable distribution analysis. Oh my gosh. All right. Today's not my day. We're going to use Olivia's chat. Nobody else type in the chat box for now. So there it is. Thank you, Olivia. You are the hero. Okay. So this is a simple fact pattern. And if you think about it, when you get your exam, 80% of your exam is the bread and butter family law issues: spousal support, equitable distribution, child support, child custody. So this is one of your bread and butter 80% questions. It is the highest point value, and it is the only one that I guarantee you will get. I would never give a family law question without having you do an equitable distribution analysis. You'll note here that the facts are a little thin, but it's about representative of what you would see in a real exam if you had to pull the material out. So what I want to do is role play or model again a answer. What are all of the things that we would need in our A answer? And the first thing that we would need to do is we would need to start by stating a rule. We don't jump in and start doing an equitable distribution analysis. Why not? Because our clients really want to understand the process. They want to understand how this is going to work. So let me start by getting a volunteer, and my dream volunteer would be someone who wasn't here last week to walk us through what are all the things you might tell a client about how equitable distribution works. And anyone who's not the person on call, I want you to listen for little add-ons of other things, other points that you could snatch up, that you could add to whatever our volunteer contributes. So who would like to walk us through a coherent, complete rule on equitable distribution? How does it work? What would we tell Cody and Sarah about how this works? Dun, dun, dun. Thank you, DJ. Go ahead.
I would start out by telling them that equitable distribution is what took the place of title theory, which was that whoever the piece of property was, the title was in their name, that's who got the property. Equitable distribution acknowledges the fact that there's disparity when you divide up anything that is property, especially if one spouse goes into the marriage with cash and the other one goes in with debt. So I would kind of, give them a realistic explanation of you're not going to come out, if you're the one that came in with cash, you're probably not going to come out with all of your cash and 50-50 of the property as well. And so when you go through the equitable distribution analysis, after you have to first determine that there is property. So property that isn't marital property is going to be determined either by time or by exception. So anything before or after legal separation is considered separate property. Exceptions of gift or, it being bestowed on you during the marriage count as separate property as well. And then after property is determined where it kind of falls, the actual analysis of contribution, value, duration, and then economic circumstances of the soon-to-be ex-spouses is determined to determine who gets what.
Who gets what from what pot?
The marital property.
Beautiful. Great. That was exceptionally well done. I love especially how you gave a sort of overview of what it is and what it's not. You walked through each of the steps and you delineated carefully the classification stage and the contribution stage. The one refinement that I was asking at the end is just to clarify that contribution only applies to the marital bucket. Any other points that folks would add? There's two things only that I can think of that I would add. Anything else? Yeah, Elizabeth?
At least in Kentucky, there's no expectation of 50-50 property distribution. So, of course, the client shouldn't go in expecting that. And it's also looked through the lens of economic need. So support, we're just doing property.
Yeah,
that's later. Right.
This is
Okay.
why I really like, no, it's great. This is why I really like tonight's lab, because we get to put multiple concepts together that crisscross very closely. But the not 50-50, if you're making notes for an open book exam, I would put that in bold and highlight it in font, every font that you can imagine, to make it unequivocal that we have to tell our clients this. There are other states. Florida, for example, is one that begin with a presumption of 50-50. We do not do that. Monica.
The other thing would be clarifying the role of the state. In the first part, when the non-marital property is distributed, there's no discretion of the court, but in the second step, there is discretion.
Beautiful. Great. And then I had only one other thing I would add, but it's super, super tiny and nuanced, so I'm just going to say it. The only other thing that I would add, and it was implicit in what DJ said, but I would make explicit, that all property is presumptively marital unless you prove otherwise. So and that matters. So far, we've actually really not dealt with a piece of property that was in dispute, where one side would argue one and one side would argue the other. That happens most often with that line between passive and active appreciation. But if that happens, and if you were to conclude it was a tie, so to speak, the presumption is marital property unless you can prove otherwise. So that, combined with everyone's wonderful participation in that stretch there, got us an A answer. It's an open book exam. Come prepared with it and be ready to explain this to your client. Do not paste the statute in there. Your client can Google the statute as well as you can. Use your lawyering skills to break down the statute just like we just did here. Brilliant. The only other tip that I want to give right now, because I don't think it came out in our coverage of equitable distribution last class, is the only way you should be doing this analysis is as a bucket. And I always use imagery and language of buckets or pots, because you don't do it incrementally. So you don't take the house and figure out, pull the pieces out and then figure out where the house goes and make arguments for the house. That instead you put everything together, you get a final number on how much is in spouse one's bucket, how much is in spouse two's separate bucket, how much sits in the marital bucket, and then with the bucket as a whole, as a big pot of debt or equity or property, then you make your competing arguments. Every once in a while, there's someone on the exam who just on the exam, has this epiphany that they're going to do this piecemeal and take it one piece of property at a time. That's not how the court does it. It does it much more holistically. Great. So that's our first step. It's super predictable. You should come into the exam prepared and ready to do that. Next, with our Bill and Brenda content here in our chat bar, can I get someone to volunteer to do the classification stage? So I encourage you to approach the classification stage with this presumption. Everything is marital unless you can pull it back out. So is there anything, can anyone volunteer to pull out of that marital bucket any content for us? Thank you, Juanita. Go ahead.
Okay. Do you want me to pull out Bill's stuff, Bill's property?
Yeah,
I'm not sure. Okay.
Yeah, go ahead. Why don't you hit someone else do hers?
Okay, so Bill, he would have the $30,000 in retirement that he acquired before the marriage, and the $35,000 in increase, assuming that the increase was because of the overall increase in the market and did not result from the efforts of the parties during the marriage. And that's Kentucky Statute 403.190, Section 2E. And he also gets the $20,000 in cash that he had before the marriage if he can trace the money to an account or purchase made during the marriage. and that's KRS 403.90, Section 1 and 2B.
Oh, beautiful. Yes, that is the A answer. It's the A answer because it identifies each of the property. And what was the total that got you to, Juanita?
That got me to $85,000, I believe.
Good. And I want to mention that because we were moving a little quickly through Sarah and Cody in our last week, and we kind of made our list, but we never properly came up with a total. If you're making a flow chart or a to-do list for the final exam and how you're going to approach it, you should stop and total it, because when you get to that distribution of the marital bucket, it matters what the total is. So Bill has $85,000. We often do a terrible job in law school pretending that everything sits in the murky maybe of exams. Every single person who took this practice problem should have $85,000 as your number. But the reason Juanita's analysis was A caliber analysis was because she identified the property. She factually explained why under the statute it yielded a particular conclusion. So you can cite the statute precisely like Juanita did, or you could cite as a gesture, a bequeathment, the timing exception, the tracing exception. Either one is perfectly appropriate, but every single piece of property should be tethered to the statute as not in a conclusory way. So you wouldn't want just a list of his property. You would want a list. If you could do it like a chart, or you could write it out. I usually like to write it out. The other thing that Juanita did that was exceptional is that she took, and this is a question I got by email from a couple folks, so I want to mention it. She actually took his retirement account and treated it really as two separate items for his separate property bucket. There was the first item, the $30,000, that was his because of the timing before marriage. And then she took the other 35 and she handled it separately, which I think is a very good strategy, because it's possible that there could have been a different answer to that. That maybe Brenda was really savvy with the markets and she actively managed it and really moved things around and followed market trends. Then that would no longer be passive appreciation of the account. So anytime you see property that before marriage was separate and then that changed in its value during marriage, try to take two separate items or line items to consider those. So that was beautiful. Great. Now somebody else volunteer to walk us through Brenda's property. What does she have and how do we know it? See, Drew, thank you.
Sorry. She has the $20,000, which was an inheritance. So that's under 403190, Part 2, subsection A, that she used in the home, and she'll be able to establish that with the tracing exception. And also the student loan debt, even though it's debt, it's hers because it was prior to marriage. So under the timing exception.
Good, perfect. And the 20,000 is sort of tracing and a bequest. So it began as a bequest, but then bequeathment, but then we can also trace it out. And then the 87,000. This is probably the first time we've done an equitable distribution analysis where there were tricks built in there. So oftentimes you'll see in old exams moments where I tell you what it was worth at another moment in time. That doesn't matter. And so here, maybe it ever so slightly matters, ever so slightly, that the couple collectively might have paid down this debt that was privately hers, but it's not a really great fact. It's really just me trying to trick you by giving you information that doesn't matter. So everything you're doing in equitable distribution analysis is largely snapshots of what things looked like when they got married, what things looked like when they separated, and what things looked like at the moment of this distribution. So the fact that there was more debt before is not really relevant here. Great, we're doing awesome so far, and I hope everybody's following along. I'll take questions in a moment. So now our last stage, and Drew, what was the total of that? Did you give that to us? I can't remember.
I did not give you the total, but she would be owing 67,000.
Good, perfect. Come up with some strategy that works for yourself. You're going to be taking this final exam just in Word or whatever word processing software you use. You could use Red for debt. You could use, just positives and negatives. You could use parentheses, whatever strategy works for you, but don't lose track of debt versus assets. So here, there's a big swing. So when we talk about their respective buckets, his bucket has $85,000 of property. Hers is $67,000 of debt. Great. Next, could someone else volunteer? And I'm working through everyone in class. So own your faith, people. So let's figure out what's left. Everything is marital property unless Juanita or Drew just extracted it from the marital property bucket. So what is left in the marital property bucket and why? Olivia.
So what's left would be the house and the mortgage, and that's going to be pursuant to KRS 403.190 Section 3 that states all property acquired by either spouse, regardless of title, is held in some form of co-ownership, such as joint tenancy, is going to be considered marital property. And so that's going to be the home, which I believe has a value of $160,000, and then minus the mortgage of $112,000, which is going to come out to $48,000.
Good, perfect. Exactly. And so here again, you have a little bit of a red herring telling you what it was purchased for. The only reason that might matter is if you had to make that fourth, like Juanita did earlier, where the property had one value, but then it increased, and that might get a different treatment. But here it's both. And one other point that I would love to see mentioned here is what relevance, Olivia, of the title. This property is in... did I tell you it's titled in Bill's name solely?
So in Section 3 of 403.190, it says regardless of whether title is held individually or by the spouses in some form of co-ownership, it's going to be community property. So it can be in one or the other's name, but it's still going to be considered community between the two of them.
Good, perfect. And so here you could go one of two ways in how you manage the things like the home, where you've got the value of the home and the mortgage. I strongly encourage you to keep them as two separate line items. The mortgage, which is your debt, and the home, which is your equity. Keep them separate and don't delta them or net them out. And the reason I encourage you to not net them out is because many people actually don't want to sell their home if they don't have to. One might want to buy the other out, or one might want to stay in it with the children. So I encourage you to think of it as two separate items and just manage your positive and negative and not necessarily do that math. Good, so that's our marital bucket. And as DJ explained at the beginning, it is the marital bucket that is subject to distribution using the equitable distribution factors. And here you really have very few facts to work with, but someone walk us through. So I encourage you for exam methodologies you'll have better facts on your real exam. Make your best argument for spouse one, make your best argument for spouse two, and your conclusion of your IRAC is always it's in the court's discretion and with using the following arguments as its guide. So does anyone have any, anyone want to take a crack at making any arguments either for Bill or for Brenda or for both? There's not a ton to work with. Brian, go ahead. Thank you.
So for Brenda, there wasn't a ton of facts, but the factors you look at are contribution of each spouse to the marital property, and it doesn't say what that is. But the two factors that were really disparate between the two that lean in Brenda's favor are value of the property set apart to each spouse and economic circumstances of each spouse. And so her value, when you look at the loans, is negative $67,000. And then his, depending on whether the retirement was active or passive appreciation, is either 65 65 or 85,000 or 65,000, I think. So either way, it's a big disparity. And we operate under the presumption that it's not 50-50, but it's whatever is in the name of fairness. And so she would be inclined to get more of the property because of the $100,000+ disparity between their financial standing.
Beautiful. Closing sentence, the judge will decide in his or her discretion. Beautiful. That's exactly how this would work. One question I've gotten from a couple of folks by email is what of the length of the marriage? The answer to that is the shorter the marriage, the more likely the court might be comfortable with disparities that existed before the marriage. If one spouse was better resourced at the beginning of the marriage and they come out kind of lopsided, courts are more comfortable with that with short marriages. The longer the marriage, then the much more comfortable the court will be with your 50-50 analysis. And I think it's a fun sort of frame of reference just to as a benchmark. So the American Law Institute, it has an approach that at 20, now I'm forgetting if it's 20 or 25, but at either 20 or 25 years of marriage, everything is presumptively marital and all of the separate property is done away with. Because at some point, how long would you keep tracing, the initial car through how many years of marriage? But that gives you a sense that 20 years is really when we start to think much more along the lines of the 50-50, what's yours is mine, what's his was hers, what's hers is hers kind of our arguments. So that's the end of that practice problem. Does anyone have any questions on that practice problem? Then I'm going to run us through just a couple little ditties that I feel like are still missing in our equitable distribution coverage. Any questions on that? Did everybody feel, Michael?
Hi, could you just run through the tracing again, if you don't mind?
The little point that I just made or the bigger point about tracing?
Kind of like the bigger point about tracing.
The bigger point about tracing that you'll apply on the exam is it's when a piece of property was separate property to begin with, but then it got turned into something else. So you got married and you had a Honda Civic and you traded in your Honda Civic for the family minivan, and $7,000 of your trade-in value came off the cost of the family minivan. That $7,000 began as separate property, and you can trace it back out as separate property. And then the point that I was just making is like at some point that becomes a little silly, like a little, like I've been married 18 years. Like, I did have a Honda Civic when we got married. I've had like 5 cars since then, right? And so like, are you really going to keep tracing that out, or does that just become silly at some point? And the answer is it becomes impossible really after a marriage of a longer length. Holly?
Thank you.
Yeah. I was just confused. I may have missed it, but I was confused on why you said that stating the $100K was her original student loan balance, like why that was like a trick at all.
Oh, I love that. Because in the end, it doesn't really matter what it was. I mean, it could possibly matter to showing the contribution. Like, the jerky argument that Bill would make is, that she just brought a bunch of debt into the marriage and that she is drained from the marriage to pay off her debt throughout. And so the fact that she's leaving the marriage with more debt doesn't mean she should get more of the marital property. It means she came in with more debt, and she should leave with more debt. But the $100,000 for the math is not relevant. So it's relevant to see that some of their marital assets have been used to pay down her personal debt. But the $100,000 is not the number that you would put in her bucket. The number you would put in her bucket is the 87.
Okay, that makes sense. I put the 87, but then when I heard you, I think I misheard you, and I thought you were saying we had to use that.
No, the other way around.
Confused. So okay, that makes sense.
Great question, Monica.
Does the down payment that Brenda put of the $20,000, does that get traced out of the marital property in any way, like the home?
Yes, it does trace back out. That's exactly. And so that is what I was describing as the like twofer of tracing, where it initially was her separate property because it was a bequeathment. And then it's traced back out, even though it becomes something different, it becomes a down payment, they can still trace it back out.
Okay.
Good. I want to just make sure I touch on just a couple of items that I don't think have gotten any attention in our equitable distribution analysis. So what if you saw on the exam some evidence of an affair where, one spouse is having an affair and that spouse is paying for an apartment for the spouse and buying lovely gifts and frolicking off on lovely secret getaways? What would you do with those facts? Why am I telling you those facts? Juanita?
Well, I think the fact that he had an affair would not be material as far as separating out the property. But the fact that he squandered the marital wealth on this affair might have a bearing on the judge's decision.
Beautiful. Good. And so I like to mention this fact, especially there's lots of ways you could dissipate marital assets. My favorite reference is in the Roberts case when they suggested going to law school was dissipating the marital assets. But here, this one's kind of tricky. If I give you those facts, because as Juanita said, the initial fact of the affair, you're going to handle in your grounds for divorce question. And you're going to say there that the other spouse, the non-cheating spouse, has a claim for adultery against the cheating spouse. And then the instinct, I think, for a lot of students taking a family law exam is to check the box. Affair, check. I dealt with that. I did something with it. But the trick with family law exam success is a lot of those facts you want to revisit your facts for every topic area you're being tested on, because the affair is relevant to grounds for divorce. It might also be relevant to equitable distribution for two totally different reasons. The first one Juanita says is the affair itself is not dispositive to the distribution of marital assets. So we don't get to punish the cheating spouse and hold that spouse to some penalty for equitable distribution. But if somehow that conduct dissipated or squandered, I like your word, the marital assets, then that is a discretionary argument that the non-cheating spouse could make to argue that whatever that offset is should yield a bigger pour of the marital bucket. You could see dissipation arguments in affairs, gambling, drinking, binge spending, any number, hiding money in separate accounts, any number of different ways that you can find those types of facts or use those types of facts. But I want to make sure my bigger point is don't see a fact, use it once and assume you're done with it. So let's carry out my adultery fact pattern. Adultery, maybe depending on how much of the facts I gave you, might also be relevant for child custody as well. If I told you that, they snuck off and the mistress and spent this money and, and somehow you could argue that it might affect the children, it might even be relevant there as well to custody or to visitation or to asking for a clause that the sleepover guest not have access to the children for visitation purposes. So every fact that I give you might have application beyond just the most obvious dominant one. Next fact. Imagine on the exam, as many real world scenarios will yield, imagine on the exam that I tell you that someone owns a small business, and this small business in 2019 did about $2 million of revenue, but currently, given COVID in 2020, is only on pace to do closer to $200,000 of revenue. Where would that fact come up on your exam? What part of the marital distribution, what part of equitable distribution? Why would I give you that, and what would you do with it? Mary Beth.
I could be wrong, but would that trigger kind of a modification?
So great point. It would not, sorry, I have a sick dog that is like under me somewhere. My little dog slipped a disc in his neck, and it's like the worst, most horrible little sound you've ever heard. He just keeps yelping, and he's sitting under my rolling chair right now, and I'm terrified I'm going to squeak him. So great point. So what Mary Beth said was, would this be relevant to a modification? And that's the problem that things like COVID are going to present here, is the answer is no. When we do modifications, we will allow modifications for spousal support, and we will allow modifications for child support, custody, and visitation. We do not do modifications for equitable distribution. It's a snapshot. And in that snapshot, there might be a lot of uncertainty. And so a lot of people, there were some really funny to me, maybe not to you, articles right when the big tax reform bill got passed a couple of years ago, of everybody strategizing when to file their divorce. There's all sorts of questions of what a business is worth. And those all sit in the valuation question. So remember, there's 4 steps. What is it property? What's it worth? Classify it, and then distribute it. And for the valuation, you would just have to make competing arguments. So if you got a question like that on the exam, the spouse who owns the business will want it to be valued much less, closer to the $200,000, and the spouse who doesn't own the business might want it to be valued much higher for the purposes of equitable distribution, or you would just have to tether the argument, and then you'll have to pick one and carry it through, or keep the 2 extremes and carry it through. But I want to mention that, though, because it would be relevant to valuation. So for all the equitable distribution we've done so far, we've never talked about a really good valuation dispute. But COVID is going to create massive valuation questions for anyone who works in the service industry. When will restaurants pick up? When will tourism pick back up? What kinds of shifts are people getting? What kinds of income is realistic? What kinds of values can we put on a particular property? Great. I saw someone's hand up. Brian, was that you? Johnny, I think I saw you up earlier. Yeah, Brian.
Yeah, I just had a quick question. I know that retirement, when it's passive, is not marital property, but I remember we did a case, I think it was last week, about how pension could be marital property for equitable distribution. And could you just touch on that for a second, the difference real quick?
Yes, absolutely. So if it's a vested pension, it's not even interesting at all. So if the person's already retired, they were in the military, their pension's already vested, they were a police officer for 20 years, and then they moved on to a different profession. If it's vested, it's not even interesting. That is income that is capable of being assigned to the individual for the purposes more for child support than anything. The challenge is unvested. And the reason that's challenging is because it has this huge valuation question of what if it doesn't vest, or what if it's never able to be paid out on properly? And that's a big issue in so many pensions right now, any public pension that's going to need, the Kentucky teachers' pensions, all sorts of automakers, public servants, all sorts of questions. And so the answer is, the first question was, is it property? And the court said, definitely yes, it is property. Second question is, what is it worth? And there, for the exam, I'll just have to give you 2 competing arguments, and then you'll use those 2 jurisdictions, the present distribution or the present division, and you would make competing arguments on the exam. Okay, and then the last thing I want to mention, because I think it's really, really interesting to ponder, and then I'll take your question, Elizabeth, is the question of same-sex couples. So we haven't talked about this yet, but it bears noting. So for equitable distribution purposes, you can get some pretty wackadoodle outcomes if you follow exactly the date of marriage for same-sex couples. So imagine you have a couple that has been partnered for 20 plus years. They might have integrated some of their assets, but they might also have a separate bank account, or they're, most of us title our car in one name, but not both. But they couldn't marry legally until 2015. So when you look at that couple for spousal support and equitable distribution purposes, they look legally to be a newly married couple, where we would be more likely to perpetuate discrepancies in equitable distribution. We'd be more likely to decline spousal support at all. And so there's lots of really interesting equitable concerns that have come up for same-sex couples that would have been married far longer and would have yielded far greater community property approaches, but because they couldn't marry, didn't. And so it's just something to keep in mind, because you would want to make arguments for that lesser resourced spouse as best as you could under the equitable distribution factors. And so for that purpose, I want to emphasize that the equitable distribution factors only tell us that you can consider the factors including those that are listed. So advocates who work particularly with same-sex couples will try to make other persuasive arguments that the court, especially if there was some other indicia of marriage, like a commitment ceremony or rings or merged accounts, that they should pretend that the couple was married, in 2000 when they had this commitment ceremony, instead of in 2015 on the actual day of the legal wedding. Okay, Elizabeth, I saw you had a question and I rudely cut you off.
No problem. I thought this was where Brian's question was going, but in our practice problem where Bill came in with the retirement account, and then it increased in value during the marriage, I saw that and said, well, Brenda isn't entitled to anything because it sounded passive, like the increase seemed like it was just part of like market swings or something like that. We didn't have any facts to say, well, she maybe actively managed it, so it increased in value. So I guess my question is there any point where we would think of also retirement accounts being like pensions and the other spouse potentially having rights to it?
Great question. So the retirement account, we did handle it the way you described with the passive appreciation. But for our purposes here, the retirement account is going to function much more like a bank account, where if you have a retirement account, you know how much is in there. There might be a penalty to access it, but you know how much is in there. There might also be a question of, well, I wouldn't have retired for another 20 years, and would the market have gone up or down, or what would it have appreciated to? But there's not the question of whether the thing even exists yet. And with that's the problem with the pension. And also, I'll add to that unvested stock options as well. And so if you have stock options, and you get a corporate job and you get stock options that vest periodically over time, they might vest or they might not vest. They might be withdrawn by the company, or they might, be underwater and worth nothing. So to be super crass about it at this moment, I will use the term unvested stock options or unvested pension on the exam if I'm triggering that, and anything else would get its ordinary equitable distribution treatment. Good question. Okay, I'm going to move us forward because I want to make sure we talk about spousal support and prenups. I think we've done a really good job of getting to mastery on equitable distribution. Let's talk prenups real quick, because I think these are pretty easy to crank out. And then we'll spend the rest of our time on spousal support. So here we have a prenup in the Sarah and Cody fact pattern. And the prenup said a couple of things. So I'm just going to walk through a couple of quick scenarios and get some answers. If you haven't participated yet, this is your moment. These are quick questions, but I want to make sure we practice applying the jurisdictional split. You will be tested on any one of those prenup jurisdictions. I'll tell you which one only when you get to the exam. So you should prepare your chart and come prepared on all three. Okay, so my first question is, if we were to find out that the prenup between Sarah and Cody was entered into on the night of the wedding, and Cody did not consult a lawyer in a simian jurisdiction, would that prenup be valid? Everything else was fine. He knew the facts accurately. Ethan, go ahead.
Yes, the prenup would be valid because under Simeon, it doesn't matter if you had access to proper legal counsel or had time to really read through the prenup because the court wants to preserve the idea of contract law in the prenup, that you can't save somebody from a bad bargain, and it would infringe upon people's rights to enter into contracts.
Beautiful. That I told you something like he had just come home from his bachelor party and he's wasted and it was put in front of him. That's when you would start to look at some sort of contract-based capacity question. Juanita, go ahead.
Well, I just would have said that if I was her lawyer, that this was a duress to bring it up so close to the wedding that, I would still argue, no matter what the jurisdiction was, that would be inappropriate. It would be duress, that it was, not fair to her to present it to her at that time. And she was emotionally not able to, think about this thing on the night of her wedding. And so I think you would still have a chance even in a contract.
So the problem with the facts that I gave you is they align pretty closely with Simeon itself, where it was like the night of. But you're right that you could definitely try to make those arguments. It would be... The interesting thing is I actually switched the genders. So if you think about who pays for weddings and who's in it financially when a wedding is, when it's the night of the wedding, under, traditionally it would be the bride that would bear the lost costs much more steeply, both socially, historically, socially, and economically in many wedding planning arrangements even today. So it's interesting because here it's actually Cody who's signing the prenup, conceding that Sarah keeps this stock, family stock, and whatever it's worth, which could be as much as over $2 million. So you're right. You would be fine to do that so long as you acknowledge that Simeon said no and said, you could still, especially if I gave you just a little bit more facts to help make a duress argument. But but Simeon is pretty clear that the social stigma of walking away from a wedding the night of is not enough under Simeon. Dimitri, go ahead.
I understand the Simeon and the case. So what would duress or misrepresentation in what's a classic thing in this context?
Good. So the misrepresentation would have to be something that would go to the essentials of that contract, representing that the person, barely has any assets whatsoever, whatever those few assets are, I want to keep them for my biological children. And so I'm not, I want a prenup to protect me. But then in reality, I'm sitting on, a patent or a drug that just went, something that doesn't reveal what the person is giving up. The person has to know what they are giving up in the prenup. So it would have to be a financial misrepresentation. I hope we all read this Melania book, by the way. But anyway, okay, Johnny, go ahead. Not the Melania book, the book about Melania renegotiating her prenup. Johnny, go ahead.
I didn't raise my hand.
Oh, sorry. Okay. I think you didn't raise your hand, but your microphone made a sound and popped you up to my big screen. Okay, let me ask a couple other quick practice problems to get at some prenup. Next, what if I told you on the exam that Cody was incapacitated in a motorcycle accident last year and is no longer able to work? Everybody in the chat bar on this one, in a Shanks jurisdiction, would the prenup be set aside under Shanks? So he's in an accident, he can no longer work. Would we set it aside in Shanks? No, guys all just following the people before you? Go back and look at your charts. Shanks does a Drew does an about face. Okay, good, nice, Liz, great. So remember, Shanks, if I were you, go open up your prenup chart right now, and I would find your entry on Shanks, and if you didn't already, highlight, bold, underline, or somehow emphasize that under Shanks, the substantive fairness test is happening at the moment of execution. So as long as when, and maybe you guys were keeping my old facts in there, that would actually explain all of your answers. So go with that. Let's go with that. So under my old facts, if it was the night before and then later he was in, then we might have a procedural problem. But from a substantive fairness standpoint, Shanks only cares if it was substantively fair at the moment that prenup was executed. So years ago. Next question, under the ALI approach, if he's in this accident, is now no longer able to work, might the court look at the prenup and be willing to set it aside? Good. So now we might be willing to set it aside. That, if I would pull open your chart and highlight and delineate that under Shanks, we look at fairness substantively at the moment that the prenup was executed. And under the ALI approach, we look at fairness at the moment the prenup is being enforced. So all those changed circumstances only matter under the ALI approach. Last question. Give it some thought before you answer, but I do want everybody to answer in the chat on prenups. In our fact pattern with Sarah and Cody, we also know that they agreed to do a joint custody arrangement of the kids. Will the court enforce that agreement from the prenup? So we know that, good, beautiful. No in big capital letters and with great clarity. The prenup can do a lot of things with respect to finances and a lot of things with respect to spousal support, but the prenup will not be binding or enforced on anything having to do with the children, because the children are a third party. They're not part of the contract, and we don't think that way. We don't allow parties to contract around their parenting obligations. Okay, Juanita, go ahead.
I'm sorry, that was from an earlier time or something.
Sorry. Okay. All right, any questions on prenups here and now? And then we're going to move to spousal support, which I think is where we need more practice, but you should not expect to see prenups super dominant on the exam. The way you should expect to see prenups on the exam are a gift from me taking something complicated out of the exam. So here, these are unvested stocks. So you can see how it could be a double whammy if you miss it, because it could distort your property distribution, but also you might spend more time than necessary dealing with something complicated that the prenup already addressed. On this, so the Sarah Cody fact pattern is actually an old exam, and I can tell you, to my earlier point about not just checking a box like, oh, I dealt with the prenup, so I'm done. The fact that they had an agreement on child custody is something that probably, I'm totally guessing here, but maybe 90% of the exams missed. So just clarifying in your child custody answer that the court would not be bound by that. So that's something a lot of people did miss. Prenups sort of sit in the genre with like jurisdiction, where like I'll sometimes test on it, but if I do, it's a small point value. Because if I put a prenup on the exam, that means I've written something else out often. So you won't see these as the sort of central part of the exam, but you will see sort of quick, small hypos worth a few points. Okay, next let's talk about spousal support. Spousal support is more often tested. It's not super hard, but it requires more restraint than most people have in their first instinct for talking about spousal support. So let's talk about spousal support for Sarah and Cody. But before we do that, I'm going to give you 4 facts to write down to work with. Because let's actually have somebody participate on this. If we were to do spousal support without me modifying anything about our fact pattern, what would the outcome likely be for Sarah and Cody, and why? Would either of them get spousal support under our facts as currently presented? Holly, go ahead.
I could be wrong, but I don't think they've been married long enough to consider the permanent spousal support, but possibly because she was a stay-at-home mom, maybe we could think about rehabilitative just until she gets like a job or training to get a better job or something like that.
Good. So she might be able, and we in the statute, we'll look at it in a second, explicitly contemplates the fact that someone is a custodian of a child, a primary custodian of a child at home. So that might be pretty important. But at the end of the day, we have to start with that needs assessment. Let me pop this statute up. Oh no. Hold on, I do have this prepared. Let me put the statute up to take a look at. So let's take a look at this statute together and just remind ourselves. For exam purposes, you should definitely have this handy among our other statutes, and you can zoom in there on the left. I can zoom in too, but I think you might need to do it on your own as well. The key thing that I want to emphasize is, and I hope you'll do in your own notes, is this swift, unequivocal, thick line separating the needs question of whether there is a financial need for one of the spouses from the how much, the what amount would we get. And so when you talk to ordinary people in your lives about spousal support and what they think about it, what their expectations are of it, most of the kinds of arguments about why people think they should get spousal support, why they think it's a good thing, all sit down here in number 2 because of the standard of living, because we were married so long, because my spouse is walking away with so much more and I gave so much. But the court cannot get to the second part, which is where a lot of our conversations and values sit, unless we can show that one of the spouses lacks sufficient property to provide for reasonable needs, which begs the question of what are reasonable needs. Is it reasonable for one spouse to live in Anchorage and one spouse to live in an apartment? If both spouses have a roof over their head, isn't that reasonable needs? Isn't that sufficient property? And in addition, that they're unable to support themselves through appropriate employment, or they're the custodian of the child. If you really stop and noodle on this first part, that is an incredibly restrictive test before you can even consider getting maintenance. And so you would have to, if you're Cody or Sarah, whichever one is going to ask for it, prove that you didn't have property to provide for your reasonable needs and that you can't support yourself, or for Sarah, that you're the custodian of a child who makes it not possible to work outside of the home. So that first step is a gateway or a key to unlocking the second step. And a lot of your clients are going to come in and chatter more about that second step. Okay, so the question I initially asked was, what would happen if I didn't change the facts? And I think if we don't change the facts, neither spouse necessarily needs it. Sarah's a little bit closer, maybe, if depending on what this investment account actually looks like. So I'm going to give you 4 facts. I hope you'll jot these down, and we'll work through them in a tweak on our existing fact pattern. So the first fact that I'm going to tell you is that Sarah gets annual gifts still of $30,000 from her parents, but her parents are aging. Second, that she does have this unvested stock, but it's not liquid, meaning she can't access it currently, and it's tied up in this family company, and she doesn't get any payouts from it currently at all. Third, this we already knew, but I just want to remind you, she was previously a guidance counselor in a public school or in a school. But the fourth one, and the one that's going to matter the most, is that Sarah has been diagnosed with Lyme disease and is struggling currently with joint pain and fatigue. So we're going to keep that in mind. And now I want us to move toward applying our spousal support statute. So I want everyone to take a minute here because now I'm tightening down our facts a little bit. It's Sarah who's seeking spousal support from Cody, and we have some new facts. So I want everyone to take 3 or 4 minutes and type something up. You could do it to me privately in the chat bar like we did last week. I thought that worked really well to help make sure everybody was accountable. And so type something up and really focus on that first part first. And if we have time, get to the second, but at least start with that first part. So your task is to start to write up a argument for Sarah as to why she should get spousal support under the facts that I gave you. So take a couple minutes, and everybody plan to send me something let's give like 4 minutes. Good. So I'm still working through answers, but I want to stop and highlight a couple of key things. Most of you have written to me a pretty substantial paragraph, like 4 or 5 sentences on just the needs assessment, the part 1. And that's exactly right. That's what you should do. And I just want to remind you to try to, if you're taking notes, like a flow chart or something like that for exam purposes, just answering this first question is a bulk of analysis. And we're skipping the rule, right? You would have stopped and explained to your client there's this 2-step process. Can't get to step 2 without getting to step 1. Even under step 1, remember, even under step 1, we need both A and B. And so I just want to emphasize here, of all the times I've ever asked you to text me something for class, this is probably the longest answer you've done yet. And that's exactly right. And so just make a note for yourself to be really restrained and cautious when you answer spousal support, to go through this element, step 1, very carefully and methodically as you are. So the arguments that I'm seeing, they are very well developed. The one area for growth that I gave to the most people is to remember the part about her being a custodian to the children. So on the one hand, there's the property arguments that she has very little property. Her parents are giving her gifts, but that gift might not be enough to meet her reasonable needs. Cody's going to argue $30,000 is plenty to meet your reasonable needs. You're still going to be getting child support, of course, to care for the kids. So this is really about her reasonable needs. She's living in her grandma's house without having to pay for that house directly. She's not working. And so $30,000 might be plenty to meet reasonable needs. And so you can see the competing arguments. And most of you, when I talked about how you sent me a nice, bulky, beefy paragraph, most of you only did the argument for Sarah so far. So remember, the next thing you would do on the exam would be to make Cody's argument back, where he would say $30,000 is plenty, reasonable needs, let's not get crazy. Most of America lives on $30,000 or far less. And so that could very easily meet that reasonable needs test. The second part is much stronger actually for Sarah, where it says, and that she's unable to support herself through appropriate employment. That's where the Lyme disease comes in, or is the custodian of a child. And here she would be both. So for Sarah, this second factor is a much more favorable, that's supposed to be an S, like a much more positive factor for her. But this one is a much more positive one for Cody between the two. And we need both, and the burden would sit on Sarah to prove both. Okay, great. Next, take a minute. I want in the chat, start another chat to me. And in that one, make a couple persuasive arguments. Let's stick with Sarah. Make a persuasive argument for Sarah under step 2 as to how much she should get and the type. So here, is she looking for permanent, rehabilitative, or limited? So in the chat, just take 2 or 3 sentences to me, making a persuasive argument that Sarah should get a bulky award, and what kind of award should she get? Great. So I'm seeing really good responses here. Again, I'm seeing folks, if you're representing Sarah, you're going to go for the biggest award you can. You can try for permanent given the Lyme disease. You could try for rehabilitative. It's very unlikely Sarah would want to ask for limited spousal support directly. Cody, of course, would want something much narrower, a limited spousal support for a year or two. And I think these Lyme disease facts are really helpful to tease out the difference between rehabilitative and limited. Because if Cody were to be required to pay rehabilitative spousal support while Sarah renews her licensing, for example, as a guidance counselor and deals with Lyme disease, who knows how long that could be. And that tethers Cody to Sarah's health outcomes and to her sort of academic and professional pursuits. Whereas limited, he could say, 2 years and then I'm done. And that should be plenty of time to deal with your illness and also to get certified to go back to work or do whatever you need to do, or the kids will be old enough to be in school. So the key things that I want to emphasize from this practice exercise with Sarah and Cody are, first, every single one of you should have this line squarely in your notes, and your answers should have that level of clarity. Second, everyone's analysis under step 1 should consider both A and B. Methodologically, you make the argument. I'll always tell you who's going to seek spousal support. So you make that person's best argument under 1, you make the other spouse's best argument under 1, and then you move to 2, make the best argument under 1 and make the best argument for the other spouse, and tether to each of your arguments the kind of spousal support that you're talking about. So for Cody, for the payor will almost always want limited for a short period of time. The requesting spouse will almost always want permanent or rehabilitative. So with our last 1 minute remaining, I'm going to fly through just a couple little quick facts just to make sure we tease out a few last points on spousal support. Let's imagine that Sarah gets spousal support and it's rehabilitative. If Cody remarries, does he get out of paying spousal support going forward? Everybody in the chat bar. No. In the group chat bar, yeah. Good. No, not for Cody's remarriage. Only if Sarah remarried. So if Sarah remarried, it would end but for rehabilitative, actually, I went too fast. Under rehabilitative spousal support, if Sarah remarried, would it end her receipt of spousal support? Give it some careful thought before you answer. I tripped my own self up a minute ago here. Under rehabilitative, would it end her receipt? I'm not sure if the old answers are the ones or not, but the answer is under rehabilitative, generally no. We'd have to look at what exactly was negotiated, but usually rehabilitative ends at the achievement of the outcome and is not tethered to remarriage. It's permanent spousal support that is distinctly tethered to remarriage. Okay. I'm going to stop there. Literally, I forgot to turn the lights on apparently in the room I'm teaching in. And I'm like, the sun is literally setting on me. So we'll stop there. I have unlimited time. So I'm going to stay online and answer any questions whatsoever. You guys did another great job. I hope it was a little refreshing to go a little bit slower and just start to build some confidence. Next week, we're going to do child support for Sarah and Cody, and we're going to talk about parentage. So we've got a lot packed in, and I'm going to have office hours, I forgot to announce this, on Sunday night at 7. I'm going to do open-ended office hours, just come and ask any questions whatsoever. And if we run out of questions and people are still there, I'll just pop up an old exam and we'll kind of talk it through. But Sunday at 7, so I'll send an email. So I'm going to stop the recording, and I invite you to peace out if you're done, but I also invite you to stay and ask any questions whatsoever. Great job tonight, everyone.